All right, viewers, the big development coming in from the courts on the Bilkis Bano case. The Supreme Court bench was hearing PILs filed for favor of Bilkis Bano, saying that the remission awarded to the 11 convicts in the Bilkis Bano case be revoked. The Supreme Court was hearing the case, and let's take you through on all the latest developments. The top court issued a notice to the Gujarat government to file its response in the matter and ask the petitioners to make the 11 convicts party to the case. The matter will be taken up for hearing again after 2 weeks' time. The Chief Justice of India questioned the exception in remission and stated that the 11 convicts will be made party to the case. Meanwhile, two big BJP leaders have broken ranks and spoken up for Bilkis Bano. BJP leader from Tamil Nadu, Khushbu Sundar, and Maharashtra Deputy CM Devendra Fadnavis spoke out against the release of the 11 convicts. Radhikapur, Bilkis Bano's village, is now seeing an exodus clearly. It suggests that Muslim families are leaving the village after the convicts were released. Remember, the 11 men were released on the August 15th under the Gujarat government's remission policy after serving 15 years in jail, leading to a massive outrage across the country. Latest that we are getting in, viewers, at this point of time, the Gujarat government has been put on notice by the Supreme Court. Two important observations that were made in the Supreme Court today. The Supreme Court, viewers, made it very clear that it was not the Supreme Court that granted remission to the 11 convicts. They guided and asked the Gujarat government to decide whether remission should be given or not. It was the prerogative of the Gujarat government. The Supreme Court also said one needs to see if there was application of mind in reducing the sentence of the Bilkis convicts. Let's listen in to all the reactions coming in.
The rules were not followed, neither the central government was consulted, nor the judge who had issued the judgment was consulted. So that is what the point of the petition was, an important point in the petition. This is such a big case with such ramifications that I think that is why the Supreme Court admitted it. This is a question of human rights, of humanity, and what kind of thinking is behind remission of this kind. Certainly the central government should have intervened by now.
Ma'am, one thing that's constantly being said since these convicts have been released is that even though the decision to grant them remission is that of the appropriate government, but at the same time this is a decision that is subject to judicial review. Now that the Supreme Court's come and issued notices on these petitions, do you think that the first step towards correcting this wrong has been taken by the top court, in your opinion?
Yes, to put the system in place and to say, yes, we will look into it. Judges were very clear, even the bench, the two judges who were there in that earlier bench, they passed that 13th May order in Radhisham's petition, one of the convicts. Even they said that we have merely asked for the applications to be considered as per law. That doesn't mean that we say grant remission. We had nothing in hand to see. We have yet not to have anything to be seen. We don't have any papers. So once remission orders are there, then everybody would be in a position to see what exactly was prevailed over the committee to even arrive to this conclusion. As I was saying earlier also, parole of this person, this particular convict, was dismissed by Gujarat High Court saying there is no favorable, the report is not favorable to him. They said, looking into the report sent by the jail authorities, we are not inclined to grant him parole. That was as recent in April 2022.
The Supreme Court was very candid enough at the time of argument that what was such a big wrong when a remission has been granted, because court had only ordered that their cases should be considered for remission. And if the remission was granted, what was such a big deal, because every day in, day out, the people are released on remission. So court was prima facie not inclined, but still they had issued notice, so we will file our appropriate reply to in this case. How can they attack on a remission order without even seeing the order? How can they make grounds in the writ petition without seeing the remission order? So this was very speculative writ petition which was filed in Supreme Court, and that too by a third party, a political outfit. So in any case, court has implemented us as party respondent in this case, and we will file our appropriate reply in this case also.
I want to bring in our legal correspondent, Nalini, who's joining us with the very latest which went on in court today. Nalini, will you break it down for us on what really happened? Because many were expecting these PILs to actually be thrown out of court, but they have been entertained to be heard 2 weeks from now.
Well, Preeti, two very important things that we need to remember from today's hearing. One, it's not Bilkis Bano who's approached the Supreme Court.
Yes.
There are other people who've approached the Supreme Court asking for this release that has been decided by the Gujarat government to now be quashed and for these convicts to be sent back to jail. Along with that, one very important thing is that even though the Supreme Court has, of course, issued notices to the Gujarat government as well as the central government asking them to respond on this very aspect as to whether or not these convicts, should their remission, should that be cancelled, should that be quashed, and should they be sent back to jail. But at the same time, what they've also done is made the 11 convicts who were part in this case, they've become party to these proceedings before the Supreme Court now. What this means, Preeti, is that these 11 convicts now will also have a say in what the future of these petitions should be. And today itself we saw that the lawyer tried to oppose the petition. So it's going to be a long-standing legal battle, no doubt about that. It's going to take at least a few hearings. But the fact that the Supreme Court has issued a notice means that the first step towards delivering justice for Bilkis Bano all over again has at least been taken right now. The Supreme Court is agreeable to considering whether or not this remission was legal, should it have been allowed, and whether or not these convicts now should be sent back to
You know, I want to ask you one quick question, Nalini, before I let you go, because there is so much talk on the remission order copy.
Yeah.
Now, we will know whether the remission was given under due course of law once that copy is with us. Nobody really has the copies. Do things go like that in court? Because you have both sides going to court without the remission copy.
Well, Preeti, the procedure that has been followed by the Gujarat government in this entire case is no doubt a little bit sketchy. Because not only is the remission order copy not available, but for the longest time, even the 1992 remission policy on the basis of which these convicts have been granted remission was not available in the public domain for the longest time until unless this entire incident happened and there was a demand to make that 1992 policy available. So the documents have not been put in the public domain. The Gujarat government says that they have not even consulted the center, which they were bound to do according to the procedure, considering that this entire matter was investigated by the CBI. So there are a lot of procedural lapses. Understandably, that the Supreme Court is going to be looking into, they are going to see whether or not a proper procedure was followed. And just because the Supreme Court had issued orders to the Gujarat government to decide on this remission does not mean that the procedures can be circumvented and the Gujarat government can take arbitrary decisions.